After being sentenced to jail for spraying the Court of Appeals building with chicken manure, I filed a writ of habeus corpus to get out of jail in the federal court. So I first tried in the state courts. They weren't going to do anything. You know, it's all protected. Judge K and the corrupt system, the illegal imprisonments and stuff. The argument, again, which is on my website, good one to read, would be McAvoy covers up for Greenberg's illegal prosecution of me. And it details everything, where I was denied my right to a counsel. I never waived any of my rights because I was never informed of my rights as required, such as the advantages and disadvantages of self-representation. There's a whole list of things that are required by both New York State and Supreme Court rulings, Court of Appeals rulings in New York, and U.S. Supreme Court rulings. I was never informed of that information, including the fact that when you're arraigned, even if you waive your right to counsel at arraignment, you do not waive your right to counsel for any further part of the proceedings. That was ignored. When I waived I never waived my right to immunity before the grand jury. For one reason, I never submitted a waiver of immunity to the grand jury as required. They have no idea what I signed. And I did not have counsel present as required to waive my right to immunity. And there was no judge present to have me waive my right. The DA says, "You're waiving your right to counsel?" I said, "Yes." That's not a legal waiver. So I filed with, the first one I filed was in 2000, May of 2000. And it was Charles Collins versus Kenneth S. Perlman, raising those issues. Judge Scullin, Chief Judge Scullin, I should say, of the Northern District of New York, stated, "Federal habeas corpus statute embodies the long-established principle that a state prisoner seeking federal habeas review of his conviction ordinarily must first exhaust available state remedies. The doctrine of exhaustion contemplates that the claim now being asserted by the way of a federal habeas corpus petition has been fairly presented to the state courts." Well, I had already presented it to the appellate court, which denied it. "The court may exercise discretion to hear and deny petitioner's non-exhausted claim. The total exhaustion rule is no longer binding." Remember that, because it becomes very important in his next decision. "The court may exercise discretion to hear and deny petitioner's non-exhausted claim. The total exhaustion rule is no longer binding." And then he goes on, "The court declines to exercise its discretion under 2254B and consider petitioner's claims by which petitioner's own admission appear unexhausted. Enforcing the total exhaustion rule in this context will encourage habeas corpus petitioners to exhaust all of their claims in state court and present the federal court with a single habeas corpus petition. Therefore, it was dismissed unless within 30 days I filed an amended petition." That was my first attempt. So, in September, I filed another one. There's the petition. There's my supporting affidavit. 52 pages long, documenting every violation of my right. These are on my website also. And this was Collins versus McLaughlin, because I was in a different jail, or I was out of jail at the time, on parole. The court issues an order. Judge Scullin again. In his petition, Collins does not specifically address the custody issue, nor does he allege that he was released on parole or is subject to some other form of custody. Therefore, I must file an amended petition within 30 days. That's fine. I file a supplemental affidavit for my writ of habeus corpus. The petitioner filing an appeal, and it states, the petitioner filing an appeal with New York State Court of Appeals would be a futile effort, as the petitioner sprayed the Court of Appeals, and it can be claimed that the Court of Appeals judges had first-hand knowledge, which they did, of the event. Further, petitioner does not have a right to appeal to the Court of Appeals, and upon information and belief, the Court of Appeals would not grant permission to appeal. That's true. The appeal from the order in the habeas corpus proceeding should be dismissed on the ground an appeal does not lie in the absence of permission. So you have to get permission from the appellate court, who wasn't going to give permission because they denied it. They don't like me because I stand up and I'm trying to expose the corruption in the court system, from the low courts, including the appellate court and the Court of Appeals. In fact, that in further support of petitioner's argument that he should not have to exhaust his state remedies, remember he did state you don't have to exhaust it under the new rules. Court is directly involved in the case for several reasons. 1. Judiciary Law 60 holds that the Court of Appeals building, grounds, and premises adjacent or appertaining thereto are under the supervision and control of the Chief Judge of the Court of Appeals. So you got a member of the Chief Judge who's in charge of the property. Direct interest in the property. Stuart Cohen, the clerk of the Court of Appeals, testified on behalf of the prosecution against me. 2 other employees of the Court of Appeals, a maintenance worker and a security guard, I won't put their names in, also testified on behalf of the prosecution. So now, and the court stenographer testified for the prosecution in my case. So I got 4 employees of the Court of Appeals building directly related, including, not including Chief Judge Judith Kaye. That pursuant to Judiciary Law 210-1, the Chief Judge of the Court of Appeals shall be the Chief Judge of the New York State and shall be the Chief Judge of the Unified Court System. States that administrative functions of the Chief Judge of the Court of Appeals. That all employees of the Court of New York State's judiciary, including judges, are under her supervision and further has control over other courts as documented by Judiciary Law 211. So she's got supervision over all these judges, including the appellate court judges. The petitioner has been deprived of his right to due process, as documented in his affidavit filed with the court on August 18, 2000, because of the position and influence, either directly or indirectly, of the Chief Judge of the Court of Appeals, as the employees of the Unified Court System would want to please their superior. They would. That as the Court of Appeals building is directly involved in this case and the employees of the Court of Appeals testified on behalf of the prosecution at petitioner's trial, the Court of Appeals has a direct interest in the case, and as such, the petitioner should not be required to exhaust his state remedies before seeking federal relief, as special circumstances exist because of the direct involvement of the Court of Appeals in this matter. And Judge Kaye also had supervision and control of the building. It's the only state building that the Office of General Services does not have control over. New order from Judge Scullin. It reveals that while Collins does appear to be in custody, has not exhausted his state court remedies, and therefore his petition must be dismissed. In his amendment, alleges that he has filed an appeal of his conviction with the New York State Court of Appeals, but that decision has not yet been rendered by the court. Since Collins has failed to fully exhaust his state court remedies, his petition must be dismissed. In other words, ignore everything I've said, just like they ignore the closed court proceedings, the right to a jury trial, court of proper jurisdiction, the illegal imprisonments in this state, they ignore it all. They keep covering it up. Then I filed a new one on November 11th, but on November 1st. That happened on the 27th. So they sent me back my supplemental affidavit showing I had complied with the law. I then filed my third one. In 2000, November, claiming that I had exhausted my state court remedies, all of them, as the Honorable, which she is not honorable, she's a two-bit lying whore, as I've documented before, because she has held that the right to a public trial, a jury trial, a court of proper jurisdiction, and other issues before you're imprisoned are not rights in New York State. Well, not substantial rights. So if they violate your rights, that's too bad. Those aren't substantial rights in New York. So I attached that. I also attempted to get the American Civil Liberties Union involved. No, they're not going to get involved because they're attorneys in it. They'll go argue. They'll send 5 attorneys to argue that a woman that gives birth to a baby with an alcohol content of 0.18, that's right, 0.18, which is also in my videos, that's okay. They'll fight for her right not to go to jail. Can you imagine that? 0.18. Alcohol for DWI is 0.08, and you got a baby being born with 0.18, and she's on probation, she's not supposed to be drinking, and she's out fighting. Makes a lot of sense. I then filed my new motion, showing that I had complied with the law and attached a copy of the denial by Judge K that stated that I had no substantial constitutional questions involved. All right, now, it's been, federal law states, if you notice, he stated I had to exhaust my state court remedies. And they had the discretion where I didn't have to, but he ignored that. Here we go again. Exhaustion of state court remedies merely requires that the state courts must have had a fair opportunity to consider the constitutional claim before the federal habeas corpus is available. I did that. I had Judge K's denial. State courts need not have decided the merits of the claims raised by the appellant in the state courts in order for him to be considered to have exhausted his state court remedies. So they don't have to rule on anything. Mine, they just dismiss. They don't rule on it. They don't address the issues of the violation of my rights. Then it goes in another case, Second Circuit, New York. The other one was also I forget what section. This one is definitely New York State, Second Circuit out of New York. Though not explicit on the point, has been interpreted to require, this is section 2254, has been interpreted to require that a prisoner need follow but one proper procedure to raise the merits of his alleged federal question in state courts. I did. The writ of habeus corpus is a procedure that I follow. The ultimate question for disposition need not be presented to state courts more than once. If the highest court in the state system has been afforded one full chance on appeal to correct the alleged constitutional error, the petitioner will not be required to pursue state collateral remedies. In other words, you only have to do it once. I did it once. I got Chief Judge K's order dismissing it. Presentation in this fashion will accomplish exhaustion regardless of whether the highest court actually decides the issues on the merits. So they don't even have to decide on the merits. She didn't. She just dismissed it. No substantial constitutional question involved. When I'm denied my right to counsel, I never submitted the waiver of immunity to the grand jury. I didn't have counsel present. I was never informed of any of my rights as required. Matter of fact, they made the argument that I know the law, so therefore they shouldn't have to give me my rights. Chief Judge Scullin again, making his final order in the case. The doctrine of exhaustion contemplates that the claim now being asserted by way of federal habeus corpus petition has been fairly presented to state courts. In order to fairly present his federal claim to state courts, the petitioner must have informed the state court of both the factual and legal premises of the claims he asserts in federal court. Exactly what I did. The state habeas corpus petition was the same as the federal one. Specifically, he must have set forth in state court all of the essential allegations asserted in his federal petition. I most certainly did, including the fact that the statute was unconstitutional, the criminal mischief statute. But the judge did, because there's no definition of it. There were two cases that supported my position, that it wasn't criminal mischief. What does the Judge Lamont do? He goes and looks at the dictionary and uses a dictionary definition instead of what two appellate courts had ruled. You would think he would use the legal. No, because that didn't suit his position. It's used the dictionary instead, because that fit his definition. That's a denial of due process, equal protection of the law, and it's case fixing. Then he states, thus, Collins clearly. Then he goes on again about being able to, at the discretion of the court and everything, same as he did before. And then he states, thus Collins clearly has not exhausted his state court remedies as to the claim that forms the basis of the present action. Enforcing the total exhaustion rule in the context will encourage. I did exhaust my state court claims. According to the New York State or the Federal Court of Appeals in New York City, you only have to give them one opportunity. But that doesn't make any difference. They're out there. They don't like it that people stand up for their rights. Judge Scullin is a traitor to the United States Constitution and the laws. How many other cases has Judge Scullin fixed for the Department of Justice or for the state of New York covering up illegal actions being taken against the citizens of the state of New York by corrupt state officials? He is a traitor to the laws of the United States. He is also a terrorist. He is terrorizing people and allowing people to be terrorized by New York State and the corrupt government officials. He joins them. He is a terrorist.